Hi everyone, in this week's dispatch video we are discussing disciplinary matters, again arising from a client query, and this specifically relates to a disciplinary issue which is started before the transfer of somebody's employment. So for example, before a business is purchased. And the question for the buyer is, what do we do with this disciplinary case? The preliminary point to flag is that disciplinary matters which have arisen in the past 2 years, which have been instituted, do need to be disclosed as part of the employee liability information obligations. So long enough before the transfer takes place, the seller, for example, would have to inform the buyer of any live disciplinary or grievance matter which had been instituted at any point in the previous 2 years. From a corporate perspective, if this is a business sale, there are probably going to be very detailed provisions within any sale or purchase agreement which go beyond that and maybe specify the precise information that needs to be provided. No particular detail on how far the employer has to go in making certain disclosures, only that they have to flag any specific cases. So it's not, for example, specified in the regulations that an employer has to go as far as providing outcome letters, investigation documents, etc. This is more about the knowledge of the case. So what happens where we have a live disciplinary issue that the seller has instituted, so perhaps by way of inviting the employee to a disciplinary hearing, and then the purchase of the business takes place. Now obviously it's possible to delay the transfer to get through that, but that's often not possible or an effective use of time, particularly where there are other employees that are going to transfer. So TUPE does operate to transfer all of the seller's rights, powers, duties and liabilities under or in connection with the employee's contracts. In this particular case, that means that the new employer stepping into the shoes of the old one is permitted to pick that disciplinary hearing up. So the employee transfers on their existing terms and conditions, so we do need to be mindful of any contractual disciplinary policy which might apply and ensure we follow that. But otherwise it is permissible for the buyer of the organisation to pick up that disciplinary exercise and ultimately make a determination on the same. One practical difficulty might be the knowledge of the buyer in terms of the specific allegations, or they may find an incomplete investigation. Hopefully the same personnel in terms of the investigating manager will still be on board. There may also be intricacies in the disciplinary policy which the buyer is not aware of. Now often the disciplinary policy will be stated as non-contractual, so it's up to the employer to decide whether they want to disrupt the process a little on transfer and introduce their own disciplinary policy into the mix. That would be a matter of fairness which will ultimately be analysed by a tribunal. But in essence, if we do have an employee who is joining us by way of an acquisition or a change in service provision, we do have the right to pick that live disciplinary up and see it through to conclusion. Hopefully you found that to be of benefit. If you do need any further advice on this or any other employment law matter, do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.